Now, according to Austin, the subject matter of jurisprudence is the positive law. The positive law, which are four essential elements, that is command, sanction, duty, and sovereignty. Now here, according to Austin, if any law do possess these four essential characteristics, it is the only law. It is the only positive law which shall be studied in jurisprudence. Then he says that law for Austin, law is a command of sovereign backed by a sanction. For Austin, law is a command of sovereign backed by sanction. Then this law which is issued by sovereign, the law which has sanction, the law which is command, is the subject matter of jurisprudence. Then what exactly the jurisprudence is? Then he tried to give definition of jurisprudence. Jurisprudence is a branch of knowledge where there is a formal analysis of legal conceptions is made. Now, formal analysis. What is formal? Formal means outer or external. The system which is related with the external or the outer side of law. The outer side of law, formal side, not informal but formal side, the side which is at the upper level, the side which is at the surface level of the legal conceptions. Different legal concepts are there in the society. The laws which are issued by the political superior authorities, the laws which are issued by the sovereign authority, and the branch, the science which deals with the formal analysis of legal conception is known as jurisprudence according to Austin. As we have seen that the jurisprudence is nothing but the science of law, whereas Holland and Austin has said this jurisprudence is the science of positive law. That is, the jurisprudence is the branch of knowledge which deals with the analysis of legal concepts. But these legal concepts are at the outer side and at the external side. Means the law as it is. The law as it is. The positive jurist or the jurisprudence does not deal with the philosophy. Philosophy is altogether a different branch, and therefore he considered natural law is not a law but it is a philosophy. It is not a subject matter of jurisprudence. It can be studied in philosophical area. Further, he said, for the purpose of making formal analysis of legal concepts, there are two branches of jurisprudence. There are two branches of jurisprudence. The first is known as a general jurisprudence, another is known as a particular jurisprudence. General jurisprudence is nothing but the science of law which is concerned with the principles and notions common to legal systems. For example, the person who studies the constitution. The constitution in India is equally applicable to all the citizens, all the persons within the territory of India. And therefore, the person who studies the constitution is studying the general jurisprudence according to Austin. And therefore, the general jurisprudence is nothing but the science which is considered with the principles and notions which is common to legal system. And the particular jurisprudence, the researchers, the academicians, the scientists or the jurists who studies any actual system of law or any portion of it is known as a particular jurisprudence. For example, the forensic jurisprudence. For example, the compensatory jurisprudence. For example, the labor laws. For example, the laws relating to women and child, the laws relating to a particular section of society, it is known as the particular jurisprudence. Means he has developed the legal research. Now it is expected that whenever you conduct a research in the form of your long-term paper, in the form of your dissertation, in the form of your PhD, it is expected that you should focus on a particular area of jurisprudence in a particular law or any portion of it. For example, I have taken that the concept of human right in natural law. Then I shall focus on the concept of human right which is developed in natural law. Then what kinds of human rights are there? How the concept of human rights is related to the natural law? How the natural law human rights are reflected in the constitution? That is the area of my study. Means the Austin has given a huge contribution towards the research of law, and therefore the Austin is considered as a father of modern jurisprudence because he has given a particular thought, he has given a concentrated efforts towards the study of law. The law, which are these four elements, command, sanction, duty, and sovereign, is the subject matter of jurisprudence. Jurisprudence is nothing but the formal analysis of legal concepts. Jurisprudence is of two kinds, general jurisprudence and particular jurisprudence. General jurisprudence deals with the principles, notions which are common to legal system. Any person, any jurist, any academics who studies the common principles which are equally applicable to legal system, then he is considered as a general jurisprudence. Then the person, the academician, the jurist who is concerned with any actual system of law or any portion of it, that is any portion of actual legal system, then that jurisprudence is considered as particular jurisprudence, such as compensatory jurisprudence, forensic jurisprudence, victimology, penology, criminology, so on and so forth. Therefore, in this way, the Austin has created a huge contribution towards the study of law, and therefore he is regarded as father of modern jurisprudence.